Trump's former chief of staff, Mark Meadows, has officially flipped in the election interference case that is being brought forth by special counsel Jack Smith. Now, we have some word in regard to the various times Mark Meadows spoke to special counsel Jack Smith and provided him cooperating information about Donald Trump and his role in attempting to overturn the election. Now, I want to be clear that we don't know the entirety of what Mark Meadows has told Jack Smith, but here's what we know as reported by ABC News. Mark Meadows has spoken with special counsel Jack Smith's team at least 3 times this year, including once before a federal grand jury, which came only after Smith granted Meadows immunity to testify under oath, according to sources familiar with the matter. The sources said Meadows informed Smith's team that he repeatedly told Trump in the weeks after the 2020 presidential election that the allegations of significant voting fraud coming to them were baseless.
What's up, people? Welcome to Dr. John Podcast. So this is happening right now. Mark Meadows has flipped. The man who sat closest to the Oval Office, who was in every meeting, on every call, copied on every sensitive communication during the most legally dangerous stretch of Trump's presidency, has been granted immunity by Jack Smith and is now a cooperating witness. He didn't slip away quietly. He sat down with federal prosecutors for multiple lengthy conversations.
Now, clearly Mark Meadows carried himself very differently, publicly speaking, and his book contradicts what he has been telling Jack Smith, according to this reporting. But he even told Jack Smith that he felt that Trump was a dishonest actor, a liar, if you will. Meadows also told the federal investigators Trump was being dishonest with the public when he first claimed to have won the election only hours after polls closed on November 3rd, 2020, before final results were even in. Obviously, we didn't win, a source quoted Meadows as telling Smith's team in hindsight. Now, keep in mind, Meadows is not someone who has had any bad blood with Trump yet. I'm very curious to see what Trump thinks about Meadows after he reads this reporting. Up until now, he has only said complimentary things about Mark Meadows. He has referred to him as a great chief of staff.
And gave sworn, detailed insider testimony under a legal agreement that stripped away his right to stay silent. ABC News confirmed it. The gatekeeper of the Trump White House is now building the prosecution's case. To fully absorb the magnitude of this catastrophe for Trump's legal defenses, we must start by examining the specific, documented, and already publicly available evidence that Meadows has produced before he ever walked into that immunity interview room.
A special friend, if you will. I mean, he's certainly special when it comes to this case.
Helping the special prosecutor.
Yeah, well, yeah. So look, there's more that we have learned about what Meadows has told Jack Smith, including the contradictions between what he's told Smith and what he wrote in his book. But before we get to that, Cenk, thoughts?
So first thought is, ladies and gentlemen, we got him.
No,
down goes Meadows. No, not Trump.
Okay.
Meadows.
All right.
Okay.
I thought you were having a mission accomplished moment.
No. We know. Okay, so down goes Meadows for now, and down goes as in he got an immunity deal, so he's going to be all right, presumably. But the most important thing is, in order to get this deal, he had to give the goods. And so apparently already testified in front of a grand jury. So this thing is locked in. You can't untestify. That stuff will be used against you later if you squelch on the deal. Then you're going to prison for sure, because you're on the record as both with Jack Smith in person and otherwise. So it looks like this thing is locked in stone. I hope that's what it looks like. It just broke. And then so Trump will turn on him viciously. He'll go from great guy, special friend to I always knew he was a loser. I always knew it. Okay, guys, this is his chief of staff. He knows exactly what they lied about in regards to the 2020 election, and exactly what. Look, the
foundation of this story is not built on speculation about what treasures might eventually be unearthed from his memory. It is built on more than 2,000 text messages that Meadows turned over to the January 6th committee, a staggering volume of real-time contemporaneous communications extracted directly from the chief of staff's own devices. 2,000 individual transmissions capturing the raw, unfiltered dialogue of the White House at its most panicked and its most conspiratorial. material.
Thing that we're all looking for here is the fake elector scheme. How much information does he have on that? Now Cheeseboro's flipped and he wrote the fake elector documents. Sidney Powell's flipped, Jenna Ellis is flipped. We're gonna get to that next. And now down goes Meadows for the first time in a long time, including Trump is in criminal trouble. In New York on the fraud case, he's in civil and financial trouble, and that's very real, and that's why he's so worried about the New York case. But this is the first time in a criminal case where I think, wow, are they actually gonna get him?
So a few things I think is worth mentioning. So Mark Meadows has not been indicted in any of these cases, whether we're talking about the Georgia election interference case or special counsel Jack Smith's federal criminal case in regard to election interference. So it is interesting to me that Mark Meadows wanted to ensure immunity before providing any testimony to Jack Smith or to his prosecutorial team.
These texts are not being sought. They have been produced, logged, reported, and analyzed. Their contents paint a portrait of a chief of staff who was acutely aware of the security powder keg being assembled, who was directly involved in coordinating the logistics of the rally that preceded the attack on the Capitol, and who was urgently begging the President of the United States to call off the rioters while the violence was happening in real time.
The only thing that we know of Mark Meadows engaging in was he was the individual who set up the phone call between Trump and the Georgia Secretary of State, Brad Raffensperger. He also, of course, repeated some of the lies, the baseless notion that there was widespread voter fraud. Now, what he says isn't the problem, right? That's actually protected speech. The question is, did Mark Meadows engage in any activity that could be criminal in regard to this case? Because look, he wanted immunity. Why would you want immunity unless you did something wrong?
Yeah, and so that is Mark Meadows and Jenna Ellis and Sidney Powell and all of those people saying, yeah, we were in a criminal conspiracy together. You don't get an immunity deal because you lied to your parents and it was slightly immoral. No, this is for legal matters, criminal legal matters. You have to admit, we did this crime together, and here's my evidence on the rest of my co-conspirators on the crime we committed.
Right.
So understand the weight of this thing. And the crime they committed was a crime.
The texts include communications confirming that Meadows had specific advanced awareness of the National Guard being on standby on the day of the insurrection, revealing that the highest levels of the administration knew the security situation was volatile and had planned contingencies for it, a fact that directly incinerates any retrospective claim that the attack was an unforeseeable spontaneous eruption
against the United States of America.
And its voters, the will of the American people and our electoral process, who we, the majority of us, wanted to be the president of the United States. Mark Meadows, along with all of these other individuals within Donald Trump's team and Trump himself, wanted to overturn the results of our democratic process and go against the will of the American people. And I am curious, now that so many people in Trump's orbit have flipped, is Vivek Ramaswamy gonna continue arguing that Trump did nothing wrong? That his behavior was protected by the First Amendment?
So Anna, it's funny you say that because on social media I put out just a couple of hours ago, not knowing anything about Mark Meadows at that moment, we've got to get every single Republican on the record about 2020.
Yes.
And the questions have to be relentless. And the press should not ask them anything until they answer the question, was the election stolen in 2020 or was it not? Because look, it's a public service announcement in a sense, because the Republican voters want to know too. And when I put that on social media, a lot of them agreed. They're like, damn right, we need to know who's on our side.
They include detailed coordination with the rally organizers, showing the procedural and logistical connective tissue between the White House operation and the event that served as the launching pad for the mob. And they include frantic messages from allies and colleagues inside and outside the building, screaming at Meadows to make Trump get on television and stop the carnage.
And realizes that the FBI and the deep state stole this election. I don't want to vote for a guy who's with the deep state. Okay, good. So the Republican voters want to know. The rest of us want to know, okay? So every Republican politician in the country should absolutely positively be forced to say, was the election stolen or wasn't it? And no, none of this greasy, well, I think this is an irregularities. No, stolen or not, who won the goddamn election?
Right.
It's a very simple question, okay?
The thing that's so depressing to me is how many people in the country, how many people surrounding Donald Trump and Trump himself are willing to essentially lie to the American people, even engage in this grift to sell books in the case of Mark Meadows, repeating the lie that the election was stolen. So let's actually get to Mark's book, okay?
Creating a contemporaneous documentary record that the president was actively refusing to act even as his own chief of staff was being begged to intervene. The significance of these 2,000 texts cannot be measured merely by their volume, though their volume is immense. It is measured by their timing. Contemporaneous communications are the gold standard of criminal evidence because they are not filtered through the fog of memory or the self-serving
Chief's chief is the name of it, very clever. He's referring to himself as the chief of staff. And what he says in his book is very different from the testimony that he allegedly provided to special counsel Jack Smith's team. According to Meadows' book, the election was stolen and rigged with the help from allies in the liberal media who ignored actual evidence of fraud right there in plain sight for anyone to access and analyze.
Oops.
So of course he's willing to say this kind of garbage in order to sell his books. Because the grift, the money, is more important than being honest with the American people, and more importantly, being honest with the American people about our electoral process and the outcome of a presidential election. Now, sources told ABC News that when speaking with Jack Smith's investigators,
spin of retrospective reconstruction. They are the thing itself. They are the private thought recorded in the moment it was thought, the private order transmitted in the moment it was given. They capture what people knew, what people intended, and what people feared at the specific moments when those mental states had their most direct, legal, and factual significance.
Meadows conceded that he doesn't actually believe some of the statements in his own book. Meadows privately told Smith's investigators that to this day, he has yet to see any evidence of fraud that would have kept now President Joe Biden from the White House. And he told them he agrees with a government assessment at the time that the 2020 presidential election was the most secure election in US history. Meadows also told investigators earlier this year that he has long believed that Trump was being dishonest when he claimed to have won the election, given the fact that votes weren't even done counting the votes yet. And before the votes were counted, Trump already declared that there was election fraud. Now, Meadows also did, of course, help Trump spread the big lie. Meadows has said publicly that he believed a number of allegations still warranted further investigation and that he hadn't reached a conclusion on the election overall by late December of 2020.
A text from Meadows about having the National Guard on standby is not a recollection offered years later during a friendly interview. It is a piece of evidence that locks in Meadows' state of mind on the day it was sent, proving that the security implications of the rally were already being managed at the chief of staff level before the first window was smashed. A text begging Trump to call off the rioters is not a staffer trying to make themselves look.
And on January 2nd, 2021, Meadows helped set up that now infamous phone call between Donald Trump and the Georgia Secretary of State, Brad Raffensperger. Now, while speaking with investigators, Meadows was specifically asked if Trump ever acknowledged to him that he had in fact lost the election. Meadows told investigators that no, he had never heard Trump say that. Now, Meadows also told Smith's investigators that around that time, there were many times he wanted to resign over concerns that the way certain allegations of fraud were being handled could have a negative impact, but he ultimately didn't leave because he wanted to help, get a load of this, ensure a peaceful transfer of power, which is why he then proceeded to publish that garbage book where he made garbage, baseless claims, of course, right?
Yeah,
I mean,
okay, so we halfway jokingly sometimes we'll say hashtag Cenk was right, hashtag Anna was right. In this case, hashtag Cenk and Anna were right. So what were we right about? First, we told you Mark Meadows is
good in a memoir. It is a real-time admission that the president had the power to stop the attack and was choosing not to use it. These texts are the evidentiary bedrock upon which the most serious obstruction and conspiracy charges are constructed, and they are already in the possession of the prosecutors. But the texts, as devastating as they are merely the public documentary record. The real seismic shift in the legal landscape comes from the immunity deal that special counsel Jack Smith has secured. To understand why immunity transforms this situation from dangerous to terminal for Trump, you have to understand what immunity means in the specific context of a cooperating witness who sits at the absolute center of a criminal conspiracy. Immunity is not a friendly chat. It is not an informal debrief. It is a formal legal agreement in which the prosecutor agrees not to use the witness's own statements against them in exchange for the witness's complete and truthful testimony. The witness loses the protection of the Fifth Amendment. They cannot plead the Fifth. They cannot decline to answer because the answer might make them look bad. They are legally compelled to sit in that chair, face their questioner, and answer every single question truthfully, completely, and under penalty of perjury. If they lie, they are not just unhelpful to the prosecution. They are criminals facing new, separate, and easily provable charges. If they tell the truth, every word they speak becomes a brick in the wall of the prosecution's case, and the prosecutor is free to use every one of those bricks against the remaining targets. Meadows, because of his specific position in the Trump White House, was not a peripheral observer who happened to catch a glimpse of one meeting. He was the central nervous system of the administration. He was in the rooms where the decisions were made. He was on the calls where the pressure was applied. He was reading the memos where the legal strategies were debated and rejected. He was in the Oval Office when the conversations about Pence, about the alternate electors, about the fake slates, about the application of pressure on state officials were happening in real time. His testimony is not the testimony of a low-level functionary who can offer one piece of a puzzle. It is the testimony of the man who can provide the prosecutors with the master key to the entire conspiracy. He can walk them through the decision-making tree. He can identify who said what, who pushed which strategy, who warned of illegality, and who ignored those warnings. He can connect the dots between the public lies about election fraud and the private admissions that the fraud claims were baseless. He can explain the intent behind the actions, which is the element of a conspiracy charge that is often the most difficult to prove without an insider. Documents can show what was done. An immunity cooperating chief of staff can tell the jury why it was done, who ordered it, and what they hoped to achieve. The Georgia RICO case represents the third and equally devastating dimension of the Meadows cooperation. The Fulton County prosecution, structured under a statute originally crafted to dismantle organized crime families, is the most comprehensive and most flexible legal weapon available for prosecuting a coordinated multi-defendant conspiracy. The RICO framework allows the prosecutor to charge every participant in a criminal enterprise not just for their own individual acts, but for the acts of the entire enterprise. It weaves all the defendants together into a single tapestry of coordinated criminality. Meadows, as the enterprise's chief of staff, is the witness who can identify the structure of the enterprise, the roles of its members, and the specific acts taken in furtherance of its illegal goals. The Georgia prosecution has already named multiple defendants, and the case is proceeding in state court, a venue where the protections and procedural advantages that Trump's federal defense team might hope for simply do not apply. And critically, Meadows himself tried to escape the Georgia case. He attempted to remove his prosecution from state court to federal court, arguing that his actions were taken in the performance of his federal official duties, and should therefore be shielded by the Supremacy Clause. A federal judge rejected that attempt. The court ruled that the conduct at issue, the coordinated effort to subvert a state's certified election results, did not qualify as a legitimate federal official duty and could not be used as a shield to escape state prosecution. That ruling is a flashing red warning siren for Donald Trump. The legal theory that Meadows used to seek removal is the exact same legal theory that Trump's lawyers have been floating as a potential escape hatch. It has now been tested, and it has failed. The precedent has been set. The Georgia case will proceed in Georgia, and the cooperating chief of staff will be a central witness in a venue where the usual playbook of delay and federal procedural warfare will not work. The content of Meadows' immunity testimony is understood to penetrate directly into the most sensitive and legally significant element of the entire election interference case, the pressure campaign against Vice President Mike Pence. The effort to force Pence to unilaterally reject certified electoral votes or to delay the certification to allow alternate slates of electors to be introduced was the constitutional climax of the entire conspiracy. It was the moment where the abstract legal theories pushed by the Eastman memos and the Giuliani press conferences were supposed to translate into an actual, concrete, and illegal action by the vice president. Meadows was in the middle of that pressure campaign. He participated in the meetings where Pence was pressured. He was on the calls where the vice president's legal team tried to explain why the scheme was unconstitutional. He was in the Oval Office when Trump berated Pence for his refusal to comply. His texts and emails document his involvement in coordinating the communications that made up that pressure campaign, and his sworn immunity testimony will provide the first-hand account of what Trump said, what Trump ordered, and what Trump intended when he directed his subordinates to pressure the vice president to break the law. This is the specific conduct that forms the core of the most serious federal charges, and the cooperating witness who can describe it from the inside is the exact kind of witness that turns a challenging case into a straightforward one. The pressure on Pence is the sharpest edge of the legal blade because it transforms the case from a sprawling narrative about political rallies and heated rhetoric into a specific, provable, and constitutionally monstrous act of attempted obstruction. The vice president's role in the certification was purely ceremonial. There was no legal ambiguity about his authority to reject electors. His own legal counsel told him so, and the White House counsel's office told the president the same thing. The pressure campaign was not a legitimate political dispute. It was an attempt to force an officer of the United States to violate his oath and the unambiguous commands of federal law. Every meeting, every phone call, every confrontation between Trump and Pence or between Meadows and Pence's staff is now on the table, and the man who is in the center of all of it is talking. The broader significance of an inner circle flip in a complex conspiracy prosecution is something that any former prosecutor will tell you is the single most important development that can occur. A cooperating witness who comes from the periphery, a low-level staffer who saw one memo or heard one conversation, is valuable. A cooperating witness who comes from the very center, the person who was in every meeting and on every call and who can provide the complete narrative architecture of the conspiracy, is priceless. Meadows is that witness. His value is not just in what he can say about specific events. It is in his ability to contextualize everything. He can explain the atmosphere in the White House. He can describe the decision-making process. He can identify who was driving the illegal strategies and who was trying to pump the brakes. He can confirm that the warnings of illegality were delivered and that they were ignored. He can provide the intent evidence that is the most difficult thing for prosecutors to establish without an insider. And he can do so with the credibility that comes from someone who was not a vocal critic of the president, but was, in fact, one of his most trusted and loyal enablers until the moment the legal walls started closing in. The cascade effect of Meadows' cooperation is another dimension that should be causing sleepless nights across the Trump legal team. When the chief of staff flips, the signal to every other witness in the orbit of the conspiracy is unmistakable. The highest level insider has decided that his own survival requires full cooperation with the prosecution. This recalibrates the calculus for every other person who might be considering their own exposure. The lawyers for lower-level staffers, for state officials who participated in the fake elector scheme, for Giuliani associates and rally organizers and everyone else who might be touched by the sprawling investigation, are now looking at the landscape and telling their clients that the train is leaving the station. The first person to cooperate gets the best deal. The second person gets a less generous deal. The last person standing when the indictment drops gets no deal at all and faces the full, unmitigated force of the prosecution. Meadows' cooperation is the starting gun for a race to the prosecutor's office, and the people who were in the rooms with him are now calculating whether their loyalty to Trump is worth the risk of being the last one standing when the charges are filed. The Georgia RICO framework amplifies this cascade effect because it allows the prosecutor to charge everyone as part of the same enterprise. The pressure to cooperate grows exponentially when a defendant realizes that they can be held legally responsible responsible not just for their own small piece of the conspiracy, but for the actions of the entire enterprise, including the actions they did not personally authorize or even know about. A state legislator who signed a fake elector certificate might find themselves legally responsible for the acts of the people who organized the rally or the people who breached the Capitol, all under the umbrella of the single RICO enterprise. The only way to escape that liability is to cooperate, to tell the prosecutors everything, and to become a witness rather than a defendant. The Meadows immunity deal is the template for every other potential cooperator. It shows what is available to those who flip, and it shows that the prosecutors are serious about using the full power of the RICO statute to its maximum effect. The failed federal removal strategy that Meadows attempted and lost is a legal precedent that deserves careful attention because it functions as a preview of coming attractions for Trump's own legal maneuvering. When Meadows argued that his actions were taken in his capacity as a federal official and should therefore be litigated in federal court, he was testing a theory that Trump's own lawyers have almost certainly been evaluating for their own client. The judge's rejection of that theory is a binding indicator of how the same argument will fare when it is made by someone else in the same proceeding. The court has already determined that the specific conduct at issue in the Georgia case, the coordinated effort to overturn a state's certified election results, is not the kind of federal official duty that the Supremacy Clause was designed to protect. That determination will be cited in every subsequent motion filed by every subsequent defendant who tries the same strategy. The escape route that Meadows tried to use has been walled off, and the wall applies to everyone, including the former president. The comprehensive picture that emerges from these interconnected developments is one in which the legal ground beneath Trump has not just shifted, but has fundamentally collapsed. The public documentary record is vast, detailed, and damning. The private sworn testimony of the central insider is now in the possession of the prosecutors, providing the roadmap and the intent evidence that the documents alone could not fully establish. The state-level RICO prosecution provides a venue and a legal structure uniquely designed for exactly this kind of sprawling multi-defendant conspiracy, and it is proceeding in a court where the federal removal strategy has already been tested and failed. The cascade effect of the Chief of Staff's cooperation is already recalibrating the incentives for every other potential witness. And the specific conduct that sits at the heart of the most serious charges, the pressure campaign to force the vice president to violate the law, is the conduct that Meadows is most centrally positioned to describe from direct personal experience. Watching how this develops requires focusing on several specific indicators. The federal election interference proceedings led by special counsel Jack Smith will provide the first signals of how the Meadows immunity testimony is being deployed. Any reference to his testimony in charging documents, in evidentiary motions, or in legal arguments will indicate that the cooperation has been fully integrated into the prosecution's case. The Georgia RICO case will continue its march toward trial, and any scheduling developments, any plea agreements from other defendants, or any new cooperation announcements will signal that the cascade effect is accelerating. The legal analysis from credible former prosecutors and constitutional scholars will provide the best available assessment of how the specific evidence categories, including the 2000 texts and the immunity testimony, are likely to impact the specific charges at issue, and any additional cooperation from other insiders will confirm that the floodgates opened by Meadows' flip are producing the kind of comprehensive insider testimony that makes a conspiracy case nearly impossible to defend. The absolute bottom line is that the legal world has fundamentally changed. The person who knew everything is now cooperating. The documentary record is extensive and damning. The RICO structure is built to handle exactly this kind of coordinated criminal enterprise. The federal removal strategy has been tested and failed. The cascade effect is real and accelerating. The pressure campaign on Pence is documented and witnessed from the inside. No honest prosecutor or legal analyst will ever guarantee a specific outcome because the justice system is unpredictable and juries are human and trials are complex. But what can be said with absolute confidence is that the combination of a cooperating chief of staff, more than 2,000 contemporaneous text messages, a RICO prosecution in state court, and a binding judicial precedent rejecting the primary procedural escape strategy creates the most comprehensively devastating legal landscape that any former president has ever faced. The evidence is documented. The cooperation is sworn. The legal structure is comprehensive. And the insider, who was in every room, is now in the prosecutor's room instead.